All right, Deputy Phillips, are we ready to go?
Yes, sir. Right now we've got Mr. Gurley here and Mr. Jocelyn.
Okay, have both of them step up.
Let's go with, please.
We also have Michael Clausen.
Okay. And then after that, Mr. Stevens is ready with Mr. Clausen. Guys, just stand right there for a second.
All right, Mr. Gurley and Mr. Joslin, Mr. Adams has been put to trial by the judge over in Rusk County. So he's in trial over there and he's unable to be here for today's hearing. So the court has had to reset each one of your cases. And my next setting that I'm available will be August 11th, and Mr. Adams will be here on that date. Mr. Gurley, I have received your complaints against Mr. Adams. I forwarded those also to Mr. Adams, and we'll take those matters up on August 11th. Okay, so I am aware of it. We'll make sure that we talk about that, but he needs to be here so we can all have that conversation. Okay. Okay. All right, Mr. Joslin, any questions? I don't have any other information on your case other than then we'll have to reset that until August 11th as well. Okay.
Yes, sir.
All right. So Deputy Phillips, if there's some pretrial, or I'm sorry, if there's some appearance there, we'll just fill those out and give that to these gentlemen. Then we'll reconvene on August 11th to take up any issues.
Yes, sir.
All right. Thank you, John.
Your Honor, Mr. Stevens is here for CR 22-00173 class.
All right, it's Mr. Klassen, if you'll step on up, CR 22-173. Mr. Stevens, do you have a copy of the indictment?
I do, Your Honor, and if it may please the court, I've gone over the indictment with my client. He'll waive reading of the indictment. He'll advise the court his name spelled correctly. He understands the nature and the consequences of the charges. Will plead not guilty to the indictment and not true to the enhancement paragraph.
All right, thank you, Mr. Stevens. All right, the court will find that Mr. Klassen has waived the formal requirements of arraignment. The court will enter his plea of not guilty and not true to the indictment and the enhancement allegations alleged therein. Court will set Mr. Klassen then for a pretrial hearing. And Mr. Stevens, what did we set your cases for this morning? I can't remember.
It was August 11th, Judge, in the morning. I do have that afternoon. I've got to be in the 392nd for a plea. So if we put it to the afternoon, I probably couldn't get here until 3 o'clock or thereabouts.
Well, in August 11th, that's only 3 weeks. I want to make sure that you have enough time to receive discovery. If you believe that's sufficient enough time, I don't mind setting it on the 11th and having you get here a little bit later that day. I've got no problem with that. But if you need more time, then we can look later.
What would the next date be, Judge?
The next date in August would be August 23rd.
Let's leave it on the 11th, Your Honor, and with the court's indulgence, that I'll be probably around 3 o'clock.
Okay. I'll just go ahead and mark it on my docket that it'll be at 3 p.m. And if you come earlier, great. If not, then I'll have it on the docket at 3 p.m.
Okay. Thank you, Judge.
All right. We'll set that for pretrial.
Thank you, sir.
You're welcome. Mr. Stevens? Mr. Stevens,
Yes, sir.
you also have Justin Hodges, and I've got verification that he's in the Nolan County Jail. Is that correct?
I believe that's correct, Your Honor.
Okay, all right. Do you have any contested pretrial motions for Mr. Hodges?
Wait, Judge, you just told he is not in the jail.
No, sir, I just confirming that he's not here.
Oh, okay. Judge, I don't have any pretrial matters that I'm aware of. I think there was a video copy that was copied last week, and I'm going to pick it up today. So I don't know that I would have any pretrial matters, but again, my client's not here, so I'm not able to discuss any of that with him.
Okay, and has he been where you can access him prior to today?
I have not tried to, Judge. I mean, I have not tried to get a hold of the jail that he's in.
Okay, all right, we'll reset it for pretrial and status on August 11th.
All right, so,
We'll also do that one at 3 p.m.
okay, Judge, that'd be great.
We'll see if we have any updates from Nolan County. Is that all you have today, Mr. Stevens?
Yes, sir, it is.
Okay, thank you, sir.
Thank you.
Well, Your Honor, we're in the process of bringing in Mr. Smith's clients.
Okay, thank you, sir.
It'll be just a minute.
That's fine.
Your Honor.
Yes, sir.
It is ready.
Are you ready on Mr. Schmidt?
Judge, I guess we can start with David Sahimi. That's a plea.
All right, Mr. Sahimi, if you'll come forward. All right, this is cause number CR 18335, State of Texas versus David Michael Sahimi. We are set for a plea. Mr. Sahimi, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, may lower your hand. Mr. Sahimi, are you a United States citizen?
Yes.
You read, write, and speak English?
Yes.
And have you ever been diagnosed with any type of mental condition? All right, in this case, you appeared before the court previously on September 18th of 2018. You pled guilty to a state jail felony offense of possession of a controlled substance in penalty group 1 less than 1 gram. Court heard the evidence on that date, found that there was enough evidence to convict you. However, the court followed a plea agreement at that time, placed you on deferred community supervision for 3 years, ordered you to pay a fine amongst other financial obligations. And it was during your period of community supervision that the state of Texas, through its district attorney's office, filed its amended motion to adjudicate and revoke your community supervision. They filed that on May 3rd, 2022. And in that motion, they've made several allegations, 8 counts to be precise, of ways that they are alleging to this court that you violated the court's order on community supervision. Have you had enough time to review that amended motion with your attorney, Mr. Schmidt?
Yes.
You feel like you've had enough time to discuss that motion and your case with him?
Yes.
And do you feel like you understand everything that you have read and reviewed with Mr. Schmidt and what you signed?
Yes.
And what you signed and where you signed, that's your true and correct signature in the paperwork. And you only signed once you were confident that you understood what you were signing. Is that right?
Yes, sir.
Okay. And Mr. Schmidt, do you believe Mr. Sahimi to be competent today?
I do, Judge.
And you've explained to him his legal rights as they pertain to this motion to revoke or motion to adjudicate?
Yes, sir, I have. In addition to that, we're prepared to go forward, waive formal reading of the state's motion. Please treat counts 1 through 8.
Great. Thank you, Mr. Schmidt. All right. The court will find that Mr. Sahimi has waived the formal reading of the state's motion to adjudicate. So at this time, Mr. Sahimi, I'm going to ask, how do you plead to counts 1 through 8 as contained in the state's amended motion?
Guilty. Oh, true. I'm sorry.
It's okay. So you've pled true to all of those counts. Have you pled true to all of those counts in that amended motion because what the state has alleged is in fact true?
Yes.
You're not pleading true to those just so you can get a cert plea agreement. Is that right?
Yes. I mean, no, sorry.
I understand. I understand. All right. Court will accept the defendant's plea of true at this time. Mr. Schmidt, any objection to the state's evidence?
No objection, Judge.
State's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we'd rest and close this time.
From the defendants?
That's the close. That's the court to follow plea agreement.
All right. Based on the defendant's plea of true to each count alleged, the court will find that Mr. Sahimi has violated the terms and conditions of his community supervision. Upon the court finding each violation to be true, the court will this date follow the plea agreement and adjudicate the guilt of David Michael Sahimi on the charge of possession of a controlled substance in penalty group 1 less than 1 gram. Court hereby revokes his community supervision, assesses his punishment in accordance with the plea agreement at 8 months confinement in the state jail division of TDC in order to pay the balance of his financial obligations. Court awards Mr. Sahimi 240 days credit towards the sentence for the time that he has spent in jail on this cause. Mr. Semi, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'll have you step over with the deputy to be fingerprinted.
Thank you.
You're welcome. Who do you like next, Mr. Schmidt?
I'm prepared on all of my male clients. I've got Martin Perez here. We can start with him.
Okay, Martin Perez, CR 2189.
Judge, we're here on a pretrial, I think, or a docket call.
Dr. Cole.
We received an offer from the state. We'd like to set Mr. Perez for a plea. Whenever.
Is it a time plea or probation?
It's a time plea.
Time plea. Right. We've been resetting you for August 11th. I don't know if you still have availability in that afternoon of that date. Or we can set him for Thursday of this week or Tuesday of next week. We need to.
How about Tuesday next week, Judge? That should work fine.
Okay. All right. The court will set Mr. Perez to enter his plea next week on July 6th at 1:30.
Judge, that's contested docket. Are we just bringing everyone over? Or just before we set it at 1:30,
You're right, Mr. Woodwide. That'll be at 9 a.m. So we'll just.
Thank you, Your Honor.
Okay.
July 6th. I wrote down.
26. July 26. At 9 a.m. Yeah, I did say 1:30, but it is a contested docket. That'd be at 9. Your next time, Mr. Schmidt.
Ronald Toll.
Ronald Darren Toll, CR 21146. Motion to revoke.
That's correct, Judge. We are set on the 7/26 docket already on the motion to revoke. I do know that one of the major issues that I have resolving any cases with Mr. Toll is we have an unindicted offense that has to be addressed. I anticipate spending some time with the DA's office this week on some of these cases, and hopefully we can have a resolution by the 26th. And if not, we may not even be prepared to go on a contested at that time, but it is already set, just so the court's aware.
Well, whatever's unindicted obviously is not before the court, so I can't weigh in on that, but the state's filed its motion, so court's going to require the state to be ready on the 26th, regardless of whether the indicted case is indicted or not. So unless there's an agreement between the state and the defense, I would leave it set on the 26th and expect some kind of disposition on this.
Well, and I understand that, Judge. I understand the court's position, and ultimately, I also understand that the unindicted case is not before the court, but as a matter of practice, difficult. I would urge a continuance if we don't have the MTR resolved, because I can't, in all good conscience, have 2 felonies that are unresolved. You'd still have 1 unresolved at that point. So we'll just, I guess, cross that bridge when we get there, Judge, but hopefully we will. Hopefully we will.
Yeah, no, and I understand the concern from the defense. Unfortunately, the state's concern is different from the court's concern, which is different from the defendant's concern. So, and I think we do need to make a correction on your other client, Mr. Schmidt, on Mr. Perez. I believe that will be at 1:30 in the afternoon. We're still bringing the jail clients at 1:30 and bail clients at 9 a.m. So if we can correct that notice of appearance for Mr. Perez to say 1:30, that way anybody wants to be here for his plea, they'll be here at the right time. So that's my mistake on that. So, all right, so we'll leave Mr. Toll set for evidentiary or contested next week. And then I believe Judge Thomas will be here. So y'all can argue to him if I'm going to leave docket notes that are going to say I would expect the state to go forward unless there's an agreement otherwise.
I understand. Thank you, Judge.
And we will discuss, Judge.
Who do you like next?
Robert Campbell.
Mr. Campbell, CR 19-108, State versus Robert Baker Campbell. Motion to adjudicate.
That's correct. If I have more second.
Yes, sir.
Judge, at this time, we've received an offer from the state during lunchtime. Haven't had time to discuss that with him. And we would like a little bit more time to address it before we proceed. And I don't think he's set on that 26 docket. At least I don't show it that way. So we'd ask that it be set on not the 26 contested, but on the contested after that. So. Does that make sense, Joe?
Yeah, it does. Let me look in this case. Let me see how many dockets he's had so far.
And I'd remind the court that we did have prior counsel prior to me. I think this is our maybe our first, second appearance. And I've been out of the country for at least half of it.
All right, court will set Mr. Campbell for contested docket on August 25th. That'd be at 1:30. Your next client.
Land.
Hey, I'm sorry, can you say that again?
Bobby Land.
Bobby Wayne Land, CR 18-145. Motion to revoke.
Judge, I make a similar announcement. I'm in negotiation with the state on the motion to revoke. We have received an offer. I think that I may have something that I can relay to the state that may adjust that one way or the other. Either way, we are already set on the contested docket for next week. And obviously we just have to leave it set for now. I understand the court's position on that as well.
Okay. All right, court will leave Mr. Land set for contested docket on the 26th.
No, because there are.
That's the CR 2218 State versus Amanda Robin Meek. Motion to revoke.
That's correct, Judge. Judge, we have an agreement with the state, and we'd like to get her 10-2 on that next week's docket if we could.
Okay, court will set her for 7/26 at 1:30 for plea. this Ms. Culpepper?
It is indeed, Judge.
All right, Jennifer Jerry Culpepper, CR 21-352 pretrial.
That's correct, Judge. We do not have any contested pretrial at this point in time. Ask that it be set for docket call on that August 9th docket.
All right, and you've been provided discovery from the state.
I do believe I have all this covered.
Court will set Ms. Culpepper then for docket call on August 9th, 1:30 if she's in jail, 9 a.m. if she makes bail.
Judge, I think I have a status on copy on Mr. Horton. I've asked them not to bring him up. But I do know that was on your docket today.
Yeah, let's go ahead and put it on the record. This is cause numbers. This is State versus John David Horton, cause number CR 21-126, 127, and 2021-90. I do have a note that as of July 15th, he was number 443 on the list for what they're requiring is maximum security for Mr. Horton. That's the notations that I have. Do you have anything else for the record?
I don't have anything for the record, Judge, and I know that the Mr. Horton was deemed incompetent quite a long time ago. It seems like it's been over a year at least, awaiting a bed. I think the only thing that I could tell the court is that I know that the court is making all efforts to try to get him the treatment that he needs. And ultimately, what I would like to do, hopefully, is discuss the actual cases with the state here shortly and see if perhaps we can't come up with an alternative solution rather than waiting for another year on a bed. And the last time that I had any communications from Mr. Horton, he did not appear to be any more coherent than he had been prior to. So I'm not certain that restoration is in the books for him, to be honest with you. And ultimately, we can't have him housed at the Van Zandt County Jail forever. So we'll hopefully come up with something creative so we can move it along.
All right, let's set him for a status. Let's let him in either September or October.
I prefer the September if we could on a Tuesday.
September 27th. I think we set one earlier for you today, did we not, on that same day?
Yeah, on Tuesday.
Yes,
Tuesday.
it is a Tuesday. Yeah, so let's set him on all of his cases for restoration status 9/27.
Sounds good. I think that's all that I have on the docket this afternoon.
It appears to be, yes, sir. I think that's right.
All right, thank you very much.
Thank you, Mr. Schmidt.
All right, Your Honor, there appears to be two left on the docket. We have not heard or seen from Mr. Ashmore or Mr. Crane. Do you know anything about that, or do we need to read the claims up?
Judge, for the court's information, Mr. Ashmore called me about 15-20 minutes before the docket. He said he was on his way. He might be a little bit late, but Mr. Ashmore did tell me he was on his way. I have not heard anything from Mr. Crane.
Okay, I'll ask Ms. Taberham to give Mr. Crane's office a call, and then we'll wait on Mr. Ashmore. Mr. Ashmore did indicate early this morning that he would be seeing us this afternoon, so we'll give him some time to appear. Thank you, Deputy Phillips. Still the jail staff, I appreciate their help, patience.
Yes, sir.
All right, we'll just stand in recess until we hear more.
Deputy Phillips,
Yes, sir.
without getting too detailed, how is Mr. Gutierrez? I know we have a competency on him. Is he fit to be in court? but per the jail's understanding?
What the jail relayed to me is that they think he's doing okay. However, there is an apprehension of how he's going to react when Mr. Ashmore arrives. So.
Mr. Crane, yes, okay.
Mr. Crane.
I remember there was an issue previously. I was just trying to get his temperature today. Thank you.
You're welcome for nothing. How did this morning go? Good.
Your Honor, we have Mr. Gutierrez here.
Okay, be just a moment.
It's probably 16, 18 foot wide. It's got a bit of bush. It's got bush. More bush. I hope we still have more.
He's got two shells of about this size and twice as big. Based on a while back, it was digital books, so I got to it. A couple of books on it, and still a good books. They're recycled. Two were obsolete, gone. So, but when I'm done with them, I'm gonna get rid of them. Yeah.
gotta have some substance. Like the true stories.
Yes.
Something, somebody went through. It's not what was good. Josh. Baseball player. Played for the Rangers.
Okay.
Of course, I like holding. What was it? That's it.
Yeah, it wouldn't be Chris Kyle's story, but it was I know. Big tall guy, dog, lives here in Texas. You were really booked by the Cliff Grossman, Garden Killer. That was it. I tried to read it for years ago, and it was a dry,
It is dry.
but I just got into a discussion with a civilian friend of mine recently. I dominated some thoughts and things about, and he's already in it. Okay, so I've got that book coming back, and let's hope you will continue your time span. Because I like the information.
Yes, yes. You ever been to one of his classes?
Uh-uh.
You read a book. Keeps it very intense and he keeps it. Like that.
He's good.
Yes.
That guy's got to be 70s.
Oh, he's got to be so. John came to go to the class he was at Tom. Yep, because he was teaching
Thank you.
in a church.
Yeah.
And he told me to kill him. But he goes on there, I'm like, okay. You're fixing to get rid of my last week. I'm sitting in the back.
I'll fix my chin on the movies.
So tomorrow, but
Marcus Luttrell, you were on the right track, so close.
true.
American Sniper, read that book. Written by Chris Kyle, and I'm reading that book. I like this guy. I like his story, but I don't like this guy. Well, then since then, I've run into people who actually went to hear him speak, or they met him at functions. And everybody that's ever heard him in person or met him really speaks highly of him. So my faith in him is renewed. But especially when you read both of those books, the book by Marcus Luttrell, he seems like such a humble guy. You know? I wasn't stealing material, but I went and tried, and I didn't have any education, but I worked on farm, and I wasn't this, but, and I just thought, man, it's a really humble fellow.
I would think there's got to be some sort of areas to, got to be super.
Well, I'll tell you, this isn't any secret to you. Troopers have got a reputation. I tell you, I've always stood up for troopers because I've always said, look at them, they're out there on their own in the middle of nowhere. Who knows how long it's going to be before help comes. Then you almost have to assume that persona, put on that now.
Can we bring Mr. Gutierrez up?
Come on up, Mr. Gutierrez, up to the podium, sir.
All right, this is cause number 2021-102-176, CR 2168. State of Texas versus Adrian Gutierrez. We were set for status on competency. Mr. Crane, you had filed a motion suggesting incompetency. The court granted your motion. Court appointed Dr. Timothy Ingram to conduct a competency evaluation of Mr. Gutierrez. Dr. Ingram has complied with the court's order and has done the evaluation, has provided the report to the court, which the court then referred to both Mr. Crane as counsel for the defendant and to the state. Court has reviewed Dr. Ingram's report. Dr. Ingram has issued the expert opinion that he believes that based on his finding, his opinion is that Mr. Gutierrez is competent to stand trial. So the issues before the court at this time are, one, whether or not there is a contest to that expert opinion of Dr. Ingram. And then I guess there is some type of issue between Mr. Gutierrez and Mr. Crane, whether or not Mr. Gutierrez and or Mr. Crane want to continue the attorney-client relationship. Let's first take up the issue of competency. Mr. Crane, have you received the report of Dr. Ingram and have you reviewed that? You're on mute, sir.
Okay, my apologies. I have been told that I've received it. However, I have not looked at it. I'm not going to protest it. I'm not a medical provider. If he's been in custody for a while now and he's competent to the person who evaluated him, that's fine with me.
And so let's take up the issue of the attorney-client relationship. Mr. Gutierrez, I believe that you filed with the court a motion to terminate court-appointed attorney. You understand that Mr. Crane is not your court-appointed attorney. You understand that you hired Mr. Crane. He is a retained attorney. This court has not appointed Mr. Crane to represent you. You understand that?
Yes, I do.
Okay, so you have the right to hire whatever attorney that you want to represent you, and you've hired Mr. Crane. Mr. Crane has filed a notice of appearance, and he's made appearances on your case. Do you want Mr. Crane to continue as your attorney?
Well, not really, no.
Okay.
He and I have not gotten along on several things, and
Okay, that's fine. And it's, if Mr. Crane were telling me that he was wanting to file a motion to withdraw, then you would have the right to object. If you don't want Mr. Crane to be your attorney, he doesn't have the right to object. So my question then becomes for you, Mr. Gutierrez, who's going to represent you if the court releases Mr. Crane as your attorney?
I need a court-appointed attorney right now. I'm indigent, unemployed. I've filed for disability when I was out, and I don't have money for an attorney. That was one of the issues between Mr. Crane and I, is he was wanting money for trial, and I don't have that money. I paid him up for pre-trial and half of trial already, and he was wanting the rest of the money, and I don't have it. I ran indigent.
Do you have any other assets or financial resources to hire an attorney?
No, sir. I sold my property. My motorhome just got crashed. The engine in my truck is blown up. I'm indigent. I don't have any money at all. Like I said, while I was out there, I was trying to get disability, and that's still pending.
Mr. Crane, does Mr. Gutierrez have any unearned retainer still on funds with you?
No. He paid me $3,500 for pretrial services, and that's all.
No. No, Your Honor, I've paid him 5,000 for pretrial and 3,500 for trial, and I have receipts of all that, you know, in my records.
So, Mr. Gutierrez, the agreement that you have with Mr. Crane is a private agreement between the two of you. If you're asking this court to remove Mr. Crane as your attorney, the court will do so. I'm not sure that I can appoint you an indigent court-appointed attorney at this time. I'd have to review your affidavit of indigency. If you don't meet those requirements, then I won't be able to appoint one for you. If you do meet, then I will. So I'm not sure until I make that review. What is it that you want me to do for you today, Mr. Gutierrez?
Well, I would like the $3,500 that I paid him for trial back.
Okay, well, there's no lawsuit. Well, listen, Mr. Gutierrez, I'm not here to mediate any kind of agreement between you and your attorney. If you and Mr. Crane have a conflict, then you need to solve that with him. If you want to sue him or file a grievance or whatever, those are things that you take up. The case before me is not to resolve some kind of claim of contractual violation between the two of you. Okay, I'm asking you today, do you want me to allow Mr. Crane to withdraw as your attorney?
Yes.
Okay, all right. Court will remove Mr. Adrian Crane as counsel for Mr. Adrian Gutierrez. Mr. Crane, you're free to go.
Thank you, sir. And
You're
everybody have a great day.
You as well. All right, so
Thank
Mr.
you.
Gutierrez, I will have to review your affidavit of indigency, and then I'll have to notify you in writing whether you receive court-appointed counsel or not. Okay?
Yes, sir.
All right, so I'm going to reset your case for August. Oh, you're already on the trial docket. Okay.
Yeah,
So
for August 1st.
for August 1st. Okay, so guess we'll find out if you're going to trial with or without an attorney at this point, since you let Mr. Crane go. All right, I'll have to notify you in writing.
Is that it?
That's it.
right, thank you.
What is there anything else that I can do for you? Is there anything else that you think I can do for you?
Well, I wanted to get on that bail lowered. You know, I have medical issues. I have a colostomy bag where I was going to have surgery done on that, and I'm trying to, you know, get those things done. Like I said, I couldn't make payments on the band, you know, the remote deal, the ankle bracelet. I couldn't make payments on that. I ran total indigent, you know. And
Okay, well, if you want me to lower your bail, then you need to file a motion. And that
I
motion,
thought I filed one. I filed one, you know, back, I believe in April.
did you
Not
serve it?
April, May.
Did you serve it on the state of Texas?
Yes, sir.
You did? What
Yes.
day? What day did you file that? I'm looking at
I
the
don't
case.
know exactly. I don't know exactly. I have a record of it there, you know, in the kiosk over there. It was notarized and filed, you know, for a lower bail.
Give me a moment. Let me look.
It was filed at the same time that I did for the lawyer, for the firing of the lawyer.
All right, Mr. Gutierrez, I'll review your case and I'll notify you in writing regarding the appointment of an attorney and your request for the motion for personal bond or bond reduction. Okay.
Yes. Did you find it in there?
I found something filed May 3rd.
Yeah.
Doesn't look like there's anything sent to the state though. So looks like your notice is defective. So we won't be hearing it today.
Okay. Thank
Okay.
you.
You're welcome. Has Mr. Ashmore arrived?
I've not seen him yet, sir.
Okay. He may be talking with his client whenever he's,
I believe he is.
okay, whenever he's available, just let me know.
Kern said something about that. He did walk in. So.
Okay, all right, thanks.
That's right, this.
Your Honor, we have Mr. Ashmore here.
All right, Mr. Ashmore, do we need to bring Mr. Manis up or not?
I'm gonna request that we do not, Judge. I did visit with him and he is looking better. He's taking a monthly shot of that antipsychotic. I can't pronounce it. It's Invega or something along those lines. But the minute I started talking about diagnoses, Terrell State Hospital, things like that, definitely some agitation. And I don't know if that merits bringing him in here. Like, I'll report to the court on the record that he's looking better and doing better. And seems to be in a less secure area in the Justice Center. I haven't had a chance to interview any of the jail staff to find out if that's just because he's acted better or what, but he's definitely in a less secure area. That being said, I don't know what, I know that there was some discussion about trying to get him to Terrell fast tracked. I know the state's not, out to keep him detained indefinitely, but we're trying to get him help to prevent just another recurring episode. So I don't know if you want to hear from Mr. Woodwhite, but I think the defense would welcome whatever the state's position is, Your Honor.
And I'll update the record with my notation that on July 15th, the Terrell State Hospital waiting list for Mr. Manis, he's number 35. So he's
Close.
he's been fast tracked, so I think he's getting close. So, and that's for competency restoration. So that's as much as I know. And I believe that I've received the same reports that you have, that he shows mild improvement after receiving the mental health medications based on the pretrial order that this court has signed. So I've heard those same mild improvements. Anything from the state?
Your Honor, I think we are comfortable with him proceeding to Terrell State as quickly as possible. If he's 35, I guess we stand pat, but we had previously submitted a motion for dismissal because we did not believe he was going to be able to be restored to competency and or in the time frame that we were given. But if he's only 35, then there's a fair chance that he makes it there. We trust in the court's wisdom on this.
Yeah, the court's going to take the state's motion to dismiss. I'm going to hold it under advisement until I get further communications from Terrell State Hospital.
He's comfortable with that, Your Honor.
Okay.
Thank you, Judge.
All right. So let's reset Mr. Manis, and I'm going to set him out 90 days. Ms. Tabraham gets reports, and she keeps tabs, as does the Andrew Center, I believe, on all of our inmates who are receiving mental health medications. So I feel good about setting it out a little bit longer and seeing how he progresses on the Terrell State Hospital list. And if should the court receive any information that Mr. Manis is taking a downturn, then Ms. Tabraham will know about it, and then we'll advise you, Mr. Ashmore, and advise the state. But let's go ahead and look at setting him out to, let's set him to the end of October. We could either do October. Do you have anything scheduled on October 25th, Mr. Ashmore? And we can and you can always appear via Zoom on that. I know it probably helps him seeing you. I'm talking to you for you to get that feel for him on how he's doing during the day. But we can always get that from the jail staff too. So should you need to appear via Zoom, we can do that as well. So that would just be a status.
Thank you, Judge. I've got it on my calendar, Tuesday, October 25th.
Okay, that'll be at 1:30.
Yes, Judge.
Okay, all right. Thank you, Mr. Ashmore. I do appreciate your work.
Thanks, Judge. You have a great day.
You as well, sir. All right, Deputy Phillips, is there anyone else that you're aware of? I think that's
That appears that the docket is done.
okay. All right, we'll tell jail staff I appreciate their help today.
Yes, sir.
Docket, and if there's nothing further from the state, then we'll be adjourned.
Yes, sir. We'll see you shortly.
Thanks, sir.
Thank you, Your Honor.
Thank you, Mr. Woodwide. Thank you, Ms. Heisel.